Interesting set of facts. Mr. Bosworth was a lawyer in the Houma area who, in the 80s, undertook the representation of a woman who lost her husband tragically in an accident. He successfully represented the widow, receiving in excess of $1 million recovery on her behalf. What took place thereafter placed him, however, within the discipline system. At the time he was able to secure the funds to fund the settlement, Mr. Bosworth contacted the widow, and at the time of dispersing the funds, spoke to her and asked her for a $50,000 loan out of her proceeds. While she was taken a bit aback, she trusted her lawyer and agreed to lend him the funds. In the year that ensued, neither the funds nor the interest that he had obligated himself to pay were forthcoming. As a result, a disciplinary complaint was filed against Mr. Bosworth with the then State Bar Association, who initiated an investigation.
If we can agree that only a certain amount of funds are going to be released, only what's required by the contract, I believe, I don't think we'd have any problem releasing the rest of the funds to Ms. Folse and to pay any medical providers.
What came about as a result of his actions was a set of charges under the old system that existed in Louisiana, and the matter was brought to the attention of the Louisiana Supreme Court. There were two principal issues. First, at the time that the request for the loan was made, was he her lawyer, or had that relationship come to an end with the successful completion of the wrongful death case? The Supreme Court held that whether or not there is an attorney-client relationship turns largely on the client's subjective belief. And in this instance, they found that the client had a reasonable belief that Mr. Bosworth still represented her at the time that he asked her for a loan. The second question that the court had to address was whether his actions constituted a business transaction with a client so that he had certain obligations to her. One of those obligations would have been to make certain that the business transaction was fair and reasonable to the client. The second obligation was to ensure that she had the opportunity to seek out independent counsel, someone who could tell her whether this was a good thing for her to do or not. Mr. Bosworth had not provided her with that opportunity, and as a result, the Supreme Court determined that because there was an attorney-client relationship, and because he had failed in his obligations to her, that he had violated the rules. Like doctors, our first tenet ought to be, first, do no harm when you're representing a client. The important thing is that the lawyer should never place his or her own interest above those of the client. In this case, that's exactly what Mr. Bosworth did. The rule that existed at the time came under the old Code of Professional Responsibility. And the specific rule that deals with conflicts or business transactions with a client was Disciplinary Rule 5-104. That rule doesn't exist anymore, but its current version is found in our current Rules of Professional Conduct 1.8a. And why do we have to have that? A lawyer who is going to engage in a business transaction with his or her client has to know that the client is at a disadvantage. There needs to be a full disclosure by the lawyer about the business transaction terms. It's got to inherently be fair and reasonable for the client. Even after all of those things can be satisfied, the client needs to know, I'm here to protect my interest as a lawyer in this business transaction. You might want to speak to some other lawyer to make sure you're getting good advice, and whether this is a good business transaction for you to enter into or not is something that someone else besides me as your lawyer needs to tell you.
Well,
it is a very unusual request that a lawyer turns to one of their clients for whom they work to ask that money be borrowed. It is one of those types of business transactions that we warn lawyers not to engage in, but if they do, make certain that it complies with the rule. Fundamentally fair to the client, fully explained to the client, and only after they've been given an opportunity to get independent advice and counsel from a lawyer of their own choosing.
Yes, ma'am. I have a letter on that point. I also spoke with her, and
It's not prohibited by the rules. Candidly, as the Chief Disciplinary Counsel, I wish it were. But because it's available, it's permitted, but we police it very carefully. Mr. Bosworth actually approached his client with a story claiming he wanted to borrow the $50,000 because he wanted to go buy a boat. Turns out that might not have been his real motivation. Mr. Bosworth was going through a difficult divorce from his wife. In the community property division agreement, he was obliged to pay off some loans that existed at a bank, as well as pay some balance of proceeds directly to his wife. When he settled this case, he had a substantial fee, something well in excess of $350,000 coming to him. What he didn't disclose to his client was that he intended to take those funds, his fee, properly earned, use them to pay off the bank loans, and then the rest of the proceeds were due and owing to his wife. In truth and in fact, Mr. Bosworth had no funds that he could keep for himself to keep his law practice afloat, hence the need for the loan. Another piece of information that he failed to disclose to his client, that had she known he was essentially penniless, she might have thought twice before lending him $50,000 unsecured. I think in general, most lawyers like to portray the fact that they're successful. I think as seen within the community, the lawyer probably believes that if they're seen to be successful, that'll generate more business. I think in reality, in this instance, Mr. Bosworth had to give her an explanation that didn't suggest that he was having financial difficulties. The need to borrow money so he could go buy a boat perhaps suggested that he was doing better in his law practice than he would otherwise want her to know about. In this instance, the facts indicated he didn't have enough money to keep his law practice going, and that's what the $50,000 was for. At the end of the day, Mr. Bosworth did make the widow whole, but only after substantial time had passed and lawsuits had to be filed. As a result, the Supreme Court suspended Mr. Bosworth from the practice of law for an extended period of time, telling him that he would only be allowed to return to the practice of law if he fully paid restitution.
and even though they're not asking for it, I'm going to pay them.
Mr. Bosworth's story is actually quite tragic. In the years after this, after being sued, his business faltered terribly. He was caught up in a criminal investigation, indicted in connection with a homicide in Houma. As a result, his practice cratered, his ability to maintain his law license was placed in jeopardy, and it ended ultimately years later with his death.
I'd like to call the hearing to order. This is the matter of the Louisiana Attorney Disciplinary Board, in re. Eddie Austin, Eddie Douglas Austin Jr., 04-DB.
Mr. Austin was a lawyer in Louisiana, but was a stockbroker before he became a lawyer. He settled in his practice in the Lake Charles area. Another lawyer in town, Mr. Babineau, needed a place to share office space, and he approached Mr. Austin to do that. And Mr. Austin's agreement with him was, whatever fees you generate from your practice, you give me half, and that'll be essentially my payment for you sharing office space with me. That agreement was struck, and the lawyers continued to office together, although not as partners, for many years. Mr. Babineau actually undertook the representation of a woman an elderly woman who thought that she was entitled to receive an inheritance from a relative who had passed away in Texas. He undertook that representation and successfully got her in excess of $380,000 of inheritance recovery from that estate. When she approached Mr. Babineau to receive her funds, she asked him if he had any recommendations or ideas how she might be able to maximize her recovery. She wasn't real happy with the interest rates that were being paid at the time. Mr. Babineau introduced her to Mr. Austin, the respondent. In that instance, the respondent sat with her, counseled with her about her money, and struck a deal with her where he would take possession of her funds and invest them on her behalf. He would be charging her a fee for those services. As time went on, however, the investment didn't pan out. And as you might expect, she became concerned about when and if her money was going to get returned. A civil suit was filed against the respondent. And at the end of the process, she ultimately received all of the funds back, but not until a substantial amount of time had passed. In the interim, she filed a disciplinary complaint with our office, alleging that Mr. Austin, the respondent, had taken advantage of her.
Well, this is the sticky part. I'm accused of entering into a contract with this woman as her counsel, right? Specifically, we don't know what that is.
The Office of Disciplinary Counsel investigated, and one of the first questions we had to answer was there an attorney-client relationship?
Well, $2,000 for her, $500 for each of her children, 10% interest. Okay, we do know what the contract is.
Our investigation suggested that there were facts that would support an attorney-client relationship.
And since we know what the contract is, because ultimately it was paid, what makes it so despicable that now it becomes dispersing without knowledge or consent?
Even though the client in depositions in the civil case had suggested that he had never really represented her as a lawyer, but she had turned to him as a lawyer for investment advice.
This is not the same as the previous case we were talking about, the Bosworth case. In the Bosworth case, he got the settlement, he turned right around and asked for $50,000, but he made no attempt to pay it back.
By the time this case went to hearing, unfortunately, the client had passed away. And we presented our case as best we could with the evidence available.
Legal services were performed on her behalf, Ms. Hutto's behalf, in Mr. Austin's office by Mr. Babineau. So I guess the real question is the relationship is sort of a mixed relationship. And it hinges on one thing. How much authority did Mr. Babineau have to act on behalf of Mr. Austin?
The hearing committee determined that there was no conflict or taking advantage of by the respondent of the client because there was no attorney-client
So
relationship.
that we can have that issue resolved?
And because of that, they recommended that the formal charges be dismissed. The Office of Disciplinary Counsel objected, and we brought our concerns to the attention of the Disciplinary Board, who reversed, finding that there was an attorney-client relationship and that therefore there had been an overreaching, a business transaction with the client. And in that instance, they found that a violation occurred that warranted the imposition of some discipline. As you might imagine, while the Office of Disciplinary Counsel was pleased with that recommendation, the respondent was not. He appealed it to the Louisiana Supreme Court, who set the matter for argument.
Why does it all of a sudden become so despicable that it's dispersing without knowledge or consent?
Like I said, in this case, there were actually 6 rule violations. 1.8A is a prohibited business transaction with a client. That rule is in place to protect to protect clients and the public from entering into business with a lawyer and not having any protections. Because usually when somebody comes to a lawyer, it's because they need help. They need legal guidance. The lawyer has training and expertise that the layperson doesn't have.
Well, she had a lot of things to be done with the money, actually.
This is what we found interesting. She clearly had gone to Mr. Babineau to represent her in connection with the out-of-state inheritance
She was only
issue.
getting a 2% return on her money, and she wanted more.
Mr. Babineau was affiliated with Mr. Austin, the respondent in this case. They were both lawyers. They both operated out of the same office. And to the public, they were viewed as law partners, even though there was no true partnership between them, but only an office sharing arrangement. Additionally, we were concerned that Mr. Babineau actually made the recommendation that his client consult with the respondent about investment advice. And what was of concern to us was whether or not a lawyer or a lawyer's role could be seen as including providing investment advice. Many lawyers do, perhaps inadvisedly. But in our judgment, there was a reasonable subjective belief by this woman that she could rely upon Mr. Austin, the respondent in our case, because he was a lawyer and apparently had a history of providing investment advice to others. And our concern was that he had failed to tell her, in his role as a lawyer, that she needed to go out and get independent counsel, someone who could tell her whether or not providing what amounted to her whole life savings to him was a wise or prudent thing to do.
Now, disciplinary counsel, I know the argument that Mr. Austin is going to make. What evidence is there in the testimony or in the records that would say that Mrs. Hutto had diminished capacity, other than the fact that she was in her 70s and she couldn't hear?
Rule .14 is the same type of thing. It's when you engage in legal activities with a client with a disability, there are extra protections necessary to make sure that that particular client is not being taken advantage of. And 1.15A is A, B, and C actually. That deals all with the trust account and the safekeeping the money of other people, third persons. It's not the lawyer's money, it's other people's money, and you have to have rules in place to tell the lawyer what they can and cannot do with that money so that theft doesn't occur, or even the appearance of theft, because the perception is reality in a lot of cases, and the rules are in place to make sure the public is comfortable dealing with lawyers and understanding that we are a profession and we are obligated to treat them both ethically and professionally.
She asked that the kids be allowed some access to the accounts, but not total access to it.
We see it happen on occasion. It is a rule that exists that allows lawyers to engage in business transactions. Whether that's a good idea or not, it is in our rules and permitted, but only if a lawyer does those things necessary to ensure that it's fair.
Correct. And lastly, just in general terms, whether the respondent violated Rule 8.4. How long do you think you all would take to?
Had occurred. 8.4A and 8.4C are the two rules that we also charged him that do not require an attorney-client relationship. Those can exist whether an attorney-client relationship is present or not. For example, we might charge you with 8.4C, engaging in criminal conduct if you get a DWI, and there's no attorney-client relationship there. Even though you're a lawyer and there's no client involved, you still could be held for violating 8.4C, depending on the circumstances of each case. And every case is fact-specific. It's very different. How this office, addresses this case, what we investigate hinges on the facts of each individual case, and that's always different. Everyone is fact-specific.
He had submitted billings and so on. So it's just like going into any other law firm. You go to one attorney in that law firm and you hire that attorney.
Hearing committees in the disciplinary board can and often do disagree. The role of our hearing committees is very, very important. One of the most important things they do is make findings of fact. They listen to the testimony. They listen to witnesses. They observe their demeanor.
See, in this other case, it's got to be either one or the other. In the other case, this Boone case, there was no agreement. There is no contract. He didn't even try to pay the money back. He just kept it. He still owed that money the day he showed up in court.
And so they're charged with the responsibility often of making credibility calls. Do we even believe these witnesses and what they're saying?
Well, she had a lot of things to be done with the money, actually. But the main request was that Well, basically, she inherited a couple $100,000 from, I believe it was her brother-in-law. And she had this money in different, various accounts. I want to say the Bank of Omaha, the Mutual of Omaha, something like that.
And because neither the disciplinary board or the Supreme Court can be there to listen to that testimony, their role as fact finders is considered to be critically important to the overall process and won't likely be overturned. In this case, the hearing committee heard testimony and read records from the underlying civil case where the woman, the client, the woman that we believe to be a client, testified that she had never hired this lawyer, Mr. Austin, as her lawyer in the inheritance case, but had been referred to him by the lawyer she had hired, Mr. Babineau, in the hopes of getting some advice and counseling about her investments and what type of a return she may be able to receive. The hearing committee, we believe, narrowly interpreted the definition of the attorney-client relationship. They determined that because her earlier testimony suggested he wasn't my lawyer in connection with the inheritance matter, that there was no basis for finding an attorney-client relationship. We argued that that was too narrow, that the policy advanced by the Supreme Court in an earlier decision in Bosworth had indicated there needed to be a client's subjective belief that there was a relationship that was akin to an attorney-client relationship to trigger the ethical obligations. The disciplinary board agreed, based on the law espoused by the Supreme Court up to that point, that the client's subjective belief was sufficient to establish the attorney-client relationship, and that when they looked at the facts, the client turned to him as a lawyer and as an advisor with regard to her investments. From their perspective, that was adequate to find an attorney-client relationship by clear and convincing evidence that would impose ethical duties under the rules of professional conduct. What made this case interesting and what made this case important in the discipline system is that the Supreme Court had the opportunity once again to revisit the issue of how do you determine if there's an attorney-client relationship or not. The client's subjective belief is surely important, but the court found that there needed to be an objective, reasonable basis for that subjective belief. In this case, they found that there simply was insufficient evidence. Interesting in this instance is that the respondent actually has left the practice of law permanently, having permanently resigned in lieu of discipline. And that came about as a result of an investigation that was initiated some years later where, interestingly enough, investments went awry and money is missing. And rather than have the Office of Disciplinary Counsel complete its investigation, this particular respondent chose to permanently resign from the practice of law rather than cooperate with our investigation or have the matter go to hearing.
I'm Charles Scholes. I'm a retired deputy sheriff, and I'm now the constable here in Bossier Parish.
In all of the years that I've been the Chief Disciplinary Counsel, I've had a number of cases that are memorable. This one is in the top 10.
On Thanksgiving Day in 2004, I received a call at home about a shooting that happened at the LexisNexis bar up north of Benton.
The Williams case has an interesting factual background.
This is a case that involved a lawyer by the name of Charles Williams, and it was an unusual case because it involved the murder of another lawyer, or the homicide of another lawyer, named Larry Broom. At the time that the homicide occurred, both of the lawyers had already been suspended by the Louisiana Supreme Court.
And Mr. Broom had a business proposition for Mr. Williams, and that was, come up here to Benton, Louisiana, a community just north of Shreveport, and help me run a nightclub, a rural nightclub. I'll pay you $700 a week, and I'll give you a place to stay. Apparently having nothing better to do, Mr. Williams decided to take him up on that offer. As time went by and the nightclub business progressed, Mr. Williams became responsible for opening the club, maintaining the club, operating the club. One fateful day, the club had closed for the evening. Both Mr. Williams and Mr. Broom had gotten some rest, but Mr. Williams was responsible for getting up the next morning and having the club open by mid to late morning for those early morning customers.
He had come down to the bar. There were supposed to be customers waiting on him. That the owner wanted him to open the bar at 11, but he didn't know that. He thought normal, like 12.
And when Mr. Broom awoke and realized that his club wasn't open, was pretty upset with Mr. Williams and called him on his cell phone and told him to get back here because he wanted to talk to him. As it happened, Mr. Williams returned packing a gun that he claimed he had on his person because when he took his early morning walks, he was afraid of snakes in the rural community.
Mr. Williams tried to engage the victim, and the victim summarily told him, "Get your things and clear out."
By all accounts, an argument ensued, and a shot was fired by Mr. Williams, fatally wounding Larry Broom and killing him. Those facts were never in dispute. Mr. Williams to this day acknowledges that he shot and killed Larry Broom. The question was, how did it happen?
Williams said that Mr. Broom started hitting on him, hit him with his left hand.
According to Mr. Williams, he was acting in self-defense. He claimed that Mr. Broom was enraged with him, began beating him,
and steady hitting him. And he had his right hand in his jacket pocket. He said, Mr. Williams said he always kept a gun there.
And this angered Mr. Williams because he thought that I assumed that he had not been given an opportunity to plead his case.
Broom told him, go for it, all the time he was hitting him.
And Charles Williams pulled a .32 caliber pistol from his pocket.
Well, he pulled out his gun and he shot him.
And shot and killed Larry Broom with one shot. When the police conducted their investigation, they found the victim's gun, but it was found inside a trailer where both men lived. The only way the police were able to gain access to find the gun was they had to get a key from Mr. Williams to gain access to the trailer. So clearly, although the victim did own a gun, it was clear that he did not have a gun with him at the time he was shot. So that kind of put a dent in the lawyer's story.
When I was called in, they already had Mr. Williams here at the courthouse, and I sat down with the other detective and we interviewed him. And
this is not a situation where you would normally expect at a nightclub to find alcohol or liquor involved. It was apparently an incident that occurred while both men were in full possession of their mental faculties.
He admitted that he did shoot him, and he told me why, just because he was hitting him, because he didn't open the bar soon enough. As I do in all my cases like that, I ask him, have I promised you or coerced you or threatened you in any way to give this confession? He said, no, sir, you haven't. I said, okay, well, thank you very much. And that's probably all we have to say. And he was booked into the max.
The Supreme Court rules provide that once a lawyer is convicted of a crime, ODC is entitled to rely on that conviction for purposes of establishing the disciplinary violation that leads to a sanction. In this case, the respondent, the lawyer, was prosecuted initially by the authorities in Bossier Parish, and so we did have a conviction to proceed on. However, later that conviction was overturned.
The Office of Disciplinary Counsel filed formal charges, but while those were pending, the respondent, Mr. Williams, decided to embark upon a risky plan. He noticed that the judge had sentenced him to 10 years, but had fully suspended his sentence, something the judge cannot do.
Well, the irony is that after he entered the plea and after he was sentenced and placed on probation, he appealed the conviction on the grounds that the sentence was too lenient, he being Mr. Williams. And because the sentence was what lawyers call an illegal sentence, because it's not within the framework or the boundaries or the parameters that judges allowed to sentence a defendant, the Supreme Court was compelled to overturn the case and send it back for a new trial.
What Mr. Williams knew, but no one else did, was that it was unlikely that the witnesses could ever be found again to go to trial. And that's exactly what happened. The district attorney decided not to re-indict Mr. Williams or charge him with the commission of a crime because they could no longer support their burden of proof.
So we were left with a situation where we knew that a crime had been committed, but we did not have a conviction.
That was important for the discipline system for this reason. Under the Supreme Court's rules that govern what we do, if there is a criminal conviction, it constitutes guilt beyond a reasonable doubt. So all we have to prove is the fact of the conviction.
It was up to the ODC to prove that this was a homicide that was committed by the lawyer without legal justification or, in other words, in self-defense.
Mr. Chairman, it's ODC's decision that evidence based on the character and culpability of a decedent of a victim in a homicide is not relevant to these proceedings.
We essentially brought an amended set of formal charges against this respondent and charged him with the violation of Rule 8.4b. It's a violation of the rules for a lawyer to commit a criminal act. And the criminal act that we were going to charge him with was a homicide. We ended up going to a formal charge hearing that lasted several days and put on a case of manslaughter against this respondent.
We were asking that he be permanently disbarred, and although he had been previously suspended, in Louisiana, a suspended lawyer always has the option and the availability of seeking to have his law license restored. I can only surmise that the defendant, the respondent, decided that he didn't want to have that avenue of relief cut off from him, and he decided he needed to appeal or to challenge ODC's case, and that's what led to the hearing where we had to put on the evidence involved. So what we were required to do was essentially go into the courtroom and present evidence as a prosecutor would to prove the lawyer's guilt to a legal standard of clear and convincing evidence, which is what we did. We obtained the district attorney's file and got physical evidence from the file, photographs, and other ancillary evidence, and presented that to a hearing committee. And in the course of that hearing, the respondent, the lawyer, defended the case as he would have done in a criminal proceeding by claiming that his actions were done in self-defense.
Then he got to the truck door and he told me to go for it. like he was gonna shoot me. So I went for it.
The ODC's theory of the case was that the lawyer, the respondent here, had essentially executed the victim because of the way and the bullet was found, where the bullet was found, and the path that it traveled before coming to rest.
I didn't really notice any bruises or anything like that. If I had, we would have called the EMS. And
the autopsy report indicated that the bullet entry occurred, I believe it was it may have been on the right side, but I think it was on the left side, and it entered below the armpit on the left side. It traveled from the front to the back, and it traveled from what they describe as superiorly to inferiorly. That means from above down to below, and lodged in the muscle at the base of the lawyer's spine. I surmised that at the time he was shot, the lawyer, the only way he could be shot in the armpit was if he was raising his arm in a defensive posture, and would have been shot. But that also required that the bullet would have entered with the shooter standing above him, which was consistent with the story that we had gotten about the respective locations of the two men at the time the shooting occurred.
One thing just led to another. And before you know it, he had pushed me. I don't know if Vernon and them saw all that. Then,
we argued to the hearing committee, to the disciplinary board, and to the Supreme Court that indicated that the lawyer had essentially executed the victim, but that was not accepted. That theory was not accepted by any of the fact finders, and I can't quarrel with that because we actually did not have expert testimony available to us to come in and testify to that fact. Obviously, if the coroner had been still alive, I would have asked him to come and give testimony, but by the time this case got to hearing, we were almost 6 years from the time of the murder, and as most experienced prosecutors will tell you, cases don't get better with time, they get worse with time. So this was one of those situations where by the time we actually got to a hearing, we were missing some key evidence. Ultimately, that didn't make any difference in terms of what the sanction that was imposed or the finding, but it would have been helpful to be able to know whether the autopsy report would have supported the ODC's theory in this case.
If the plea agreement is found to be illegal, Mr. Williams, do you believe that in some way your actual plea of guilty to the manslaughter plea bargain, the plea itself, or just the sentence would be?
The hearing committee found that the shooting that occurred was not one in self-defense, that there had not been a shot fired by Mr. Broom against the respondent, and in fact the respondent's tale, that he had been pummeled by the decedent, proved false. The medical records that we obtained from the time shows there were no bruises or abrasions on this respondent to suggest that he had been in a fistfight with anyone. At the end of the day, the Office of Disciplinary Counsel was able to prove by clear and convincing evidence not only that the respondent killed the decedent, but that he did so without cause and not in self-defense.
We have a rule in Louisiana, 8.4b, which is Commission of Criminal Act. You can also charge somebody with violating the disciplinary rule, which is Rule 19, Section 19, which is conviction of crime, and that depends whatever crime you have. But in this instance, because we didn't have a conviction, we had to prove that the lawyer committed a criminal act. And so that would be 8.4b, and the court has held in many cases previously that the ODC is it permitted to prove a crime just by alleging that, but they're not entitled to the presumption of law that attaches when you have a conviction, which means that we have the legal responsibility to establish each and every element of the offense to a clear and convincing standard.
That he wanted to show the character and propensity by providing this of Mr. Broom. And unfortunately, character of the decedent is of no issue in this proceeding.
Remember that in lawyer discipline proceedings, our burden of proof is clear and convincing evidence. But in a criminal case, the burden of proof is beyond a reasonable doubt. And that's a much higher burden, and it should be.
Let me add to that the thought of two suspended lawyers packing heat, hanging out in front of a bar, shooting at each other is not exactly the impression I want to give to the public.
The matter was taken up by the Louisiana Supreme Court on its appellate review, and they found that the hearing committee findings of fact were fully supported by the record, found that a violation of the rules had occurred, and that the respondent should be permanently disbarred from the practice of law for his conduct.
So he's telling me, get off his property, such and such, so on, and one thing just led to another. And before you know it, he had pushed me from the back of the truck all the way. I don't know if Vernon and them saw all that. Then he hit me on the left side of my jaw. He got to the truck door and he told me, go for it. I thought he was going to shoot me, so I went for it. I was going to hit him in the arm or something.
I have to admit, this is the first homicide case that we've tried in our office, but it's not unusual for us to bring formal charges against a lawyer alleging criminal acts when the underlying matter either wasn't prosecuted or was prosecuted at a lesser offense that didn't capture the real essence of what the lawyer did. The Supreme Court mentioned that in our case in Williams, specifically saying that the Office of Disciplinary Counsel has the burden of going forward and proving a case by clear and convincing evidence when there is no conviction. And in this case, they found we had done that. And by all accounts, they had been friends for a period of 35 years or more. Because there was no eyewitness to the actual shooting, no one will ever know exactly what transpired between these two friends that could have led to such a tragic loss of life. What we do know, and what the evidence that we presented demonstrated, is that the respondent, who fully acknowledged that he pulled the trigger that fired the fatal shot, wasn't doing so in self-defense.
Unfortunately, this case was handed down by the Louisiana Supreme Court in January of 2012. I just learned a few days ago that Mr. Williams passed away in June of last year. So he was 67 years old, and I will say that all my dealings with him were very cordial, very collegial. It's one of those things where people do things that they probably, if they were having a moment to reflect and think about it after it happened, they probably wouldn't have done it, but they get caught up in the emotion of the moment and do things that they ultimately regret. And that's, although Mr. Williams never acknowledged committing a murder, my sense is if you look down into his soul, he would probably admit to you that he was very, very sorry that this had ever happened. I would say only the thing that I tell every lawyer who is faced with the possibility of a disciplinary action against him. It's that, lawyers work long and hard, study long and hard. It's a very expensive process to gain a law license. I know that I did, and I value my law license. And before you put your license in jeopardy, if you're thinking about doing something, maybe you would want to take a moment and reflect. Sleep on it before you do it if you think you're going to be put in disciplinary jeopardy, because your law license is a valuable commodity, and as lawyers we kind of value ourselves as people based on what we do for a living, and just treat the law license with the respect that it deserves.
One of the things we tell lawyers all the time is that you're a lawyer 365 days a year and 24 hours a day. The conduct that you engage in, whether related to the practice of law, may well have an impact on your license. It's not okay for a lawyer to commit a criminal act. It's not okay for a lawyer to do things, even in their time away from the actual practice of law, that's harmful to others. When lawyers commit criminal acts, it becomes incumbent upon us as a profession to address it. In this instance, 2 lawyers put themselves in a horrible position, and the violence escalated to a point where a tragic loss of life resulted. The best thing that we can tell lawyers in our state is be mindful of your ethical obligations to conduct yourself, even when not associated with the practice of law, in a way that brings honor to your profession.